Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس يأتيكم الآن على الهواء مباشرة. إذا كل يوم موضوع جديد في برنامج يور رايتس مع المحامية جومانا كيروز واختصاصات قانونية عديدة يقدمها أيضا محامين من مكتب المحامية جومانا كيروز، اختصاصات البيرسونال انجري، كار اكسيدنتس، قضايا الاميجريشن، قضايا الإفلاس، كريمنال لو، فاميلي لو، وسوشيال سكيورتي وإصابات العمل. الاستشارة مجانية في مكتب المحامية جومانا كيروز 248-557-3645. دائما بإمكانكم الاستماع مرة أخرى إلى حلقات برنامج يور رايتس على الموقع الإلكتروني yourrights.com/radio أو على اليوتيوب. كل ما عليكم هو البحث عن قناة جومانا كيروز. اليوم هو ثلاثاء، حلقة جديدة من موضوع البانكربسي وقضايا الإفلاس مع المحامي مايكل بانكستين والمحامية جومانا كيروز. أهلا جومانا.
صباح الخير رامي، يعطيك ألف عافية. صباح الخير لكل المستمعين وصباح الخير إلى المحامي مايكل بانكستين. Good afternoon, Michael.
Marhaba, Joumana.
Happy
Marhaba, Rami.
Tuesday, Michael.
Happy Tuesday.
Good job, Michael. Michael, in a previous show, we were asked the question about how does bankruptcy affect someone's credit score. We started that discussion. We made some valuable points. The first point is that no one needs to know about your bankruptcy, which is a reason that weighs heavily on some people's mind, thinking that their neighbors and their friends and their boss is going to know. The answer is no. Secondly, people think that they failed because they are filing for bankruptcy. And we went into greater detail about, nothing is a failure. It's a lesson. If you let it be, if you stop, if you reflect, maybe you can learn insights and maybe you can do better next time. And the third thing that we wanted to talk about is, yes, of course, the filing for bankruptcy does affect your credit score. In fact, what does happen exactly to your credit score? It goes down. How low does it go?
It doesn't go lower than
400?
Around 400 or so.
Correct. And you said that the first maybe year to year and a half are the most critical in rebuilding your credit score.
That's correct. It'll take about 18 months or so after the filing of the bankruptcy before your credit score starts to improve enough for you to notice the difference, assuming that you don't get behind on anything else moving forward after you filed for bankruptcy.
Okay. And you also stated that the week after you file for bankruptcy, your mailbox will be flooded with credit card offers.
That's
you
correct.
may or may not like them. You may be relieved that you can still open a credit card and have some credit. You may be disappointed and upset when you see that the interest rate charged by these credit card companies, who know you cannot file for bankruptcy anymore, and who know you are in a tight financial situation, and therefore you may need to open one of those, will charge you an exorbitant, very high interest rate. What kind of interest rate have you heard about shortly after the filing of bankruptcy?
I've seen anywhere from 18 to 31%.
That is outrageous. However, some people will be grateful. that they can open a credit card so soon after bankruptcy and hopefully use it when needed and where necessary.
It doesn't do you any harm, whatever the interest rate is, so long as you make sure that you don't charge more than you can pay off by the end of the month.
Correct. And we give a general rule for people when we talk about credit scores. We're not talking about people who are emerging from bankruptcy and trying to rebuild their credit score. We're talking about people who have not filed for bankruptcy. And we gave them the rule of the credit to debit ratio, where we said that if you have a credit card, try not to put more than 40 to 50% of what's allowed on it. So if you have a card with a limit of 1,000, yes, you can put 1,000, but that's not good for your credit score. Try not to put more than $400 on it on any one given time.
That's right. If you get too close to the credit limit, that's going to be a red flag and hurt your credit score.
Correct. So that's sound advice for everyone. If you have 5 credit cards, same thing. Do not put them more than 40 to 50% of what you can put on your credit card, because that's one of the factors that the 3 credit bureaus, Equifax, Experian, and TransUnion, look at to calculate your credit score.
Another thing you want to kind of look at, too, is try not to open too many cards all at the same time. So if you're opening a card every month for 4 or 5 months, that can be a red flag, too, because if there's a really abrupt departure in how much your credit limit is, that also can be a red flag.
Are you giving that advice to people who are emerging from bankruptcy or to everyone?
I think that's good advice for anybody, bankruptcy or no.
Right. So again, we're talking to people who are not in bankruptcy, and we're saying just because you can put $10,000 on your credit card does not mean to, unless you're going to pay it all back at the end of the month, no problem there. Then by all means, use somebody else's money, a corporation's money, because you're allowed to do that, and pay it all in full. If you can put $30,000 and pay it all in full when it's due, then put $30,000. But given that most people do not, they will put money on the credit card and then they will not pay it in full. So the interest rate goes up, and it's interest rate upon interest rate. It becomes compound interest rate. But they're excited because they bought something on sale. But what happens to that thing you bought on sale? By the time you're done paying it, because you're paying less than what's on your card, that thing you bought on sale is no longer on sale. If you add all the interest on top of what you paid, it's now an exorbitant amount. And I think some people don't think about that. But again, going back, for those who cannot pay their credit card in full, do not put more than 40 to 50%. It's called the debit to credit ratio. You must keep it good. Now, for those people, Attorney Michael Bankstein, who want to rebuild their credit because they just emerged from bankruptcy and do not want to open one of those ridiculously high interest credit cards, but want to take an action. I remember we had a caller who called, and as she was listening to us give the advice, she said that's exactly what she was doing on her way to her bank to do exactly what we were talking about. For those people who do not want to open those credit cards, what can they do? What is something that they can do toward increasing their credit score?
Well, one of the things they can do is they could get a secured credit card. That's a little bit different than just like a regular credit card, because you pay a deposit. There's a certain amount that you pay, that there's a deposit sitting out in front of the bill. So essentially it's your money, so long as you're not charging too much on it at any one time. But it does help to improve your score.
Where does one get a card like that?
Well, there's a number. A lot of the established credit card companies will have secured credit cards.
So you call and you say, do you have a secured credit card?
Yeah, you absolutely. It doesn't hurt to call them up and see what they have available.
And you must have that money. You must have that money or borrow it from someone. If I go to my bank and I want to open a secured credit card for $1,000, that means I have $1,000 in the bank.
Yeah, you're gonna have to. Yeah, you're gonna have to pay a deposit. It's gonna have to be your money.
It almost sounds ridiculous. So why do I need to buy a secured credit card on money I already have? I think because you're trying to prove like a little child that you learned your lesson and now you are disciplined to pay on time.
I would put it a little differently. I would put it that this is a transition back to greater credit score, greater credit responsibility post bankruptcy.
Okay, so it's a little bit like what I said. You're kind of proving to the credit reporting agencies that you've learned your lesson, that now you can be trusted to pay on time.
Well, that's correct.
Okay, that's what a secured credit card. And quite often, your bank will have a secured credit card. If not, you can call your old credit cards or a new credit card and inquire. Now, let me ask you a question. Your credit cards, when you file for bankruptcy, do they send you a letter closing out the card? They're going to be notified as a creditor that you filed for bankruptcy. What happens, practically speaking? Does one get a letter? Does one try to go run the card again? It doesn't work?
No, what happens is when you file for bankruptcy, you list all of the people that you owe money to. And then when you file the bankruptcy petition to the court mails notice out to all of your creditors. And as soon as they get notice of the bankruptcy, there's something called an automatic stay that goes into effect. That means that your creditors can't call you, they can't write you, they can't sue you, they can't garnish you. Everything has to stop. So precisely because of the automatic stay, you're not going to get a lot of correspondence from the credit card companies. But what they tend to do is then they charge it off on your credit report.
Okay, so you filed for bankruptcy and you owe credit card $10,000. They can't write to you anymore. Now you are in the middle of bankruptcy. You try to use your credit card again.
Oh, they're going to close those cards. Yeah, when you file for bankruptcy, they tend to close the cards.
Will they notify you or?
No, they're just typically they don't send you a lot of notices. They may send something, potentially to your bankruptcy attorney if you have one, but they don't really send you much correspondence. They don't want to be seen as violating the automatic stay.
Understood. So when you go to use that credit card, the charges will not go through.
Well, if you met with me, I'll tell you, don't even try to use the credit card. Yeah,
Why is
for sure.
that?
Because again, let's say that there's a card that hasn't closed and now you're incurring new debt while you're in the bankruptcy, that can be a big problem. You need the court's permission when you're incurring new debt inside of a bankruptcy. So you don't want to just go ahead and do that. You could jeopardize your bankruptcy.
Incurring new debt during bankruptcy is not something we have talked much about before.
We haven't, because it happens more in the context of a Chapter 13 bankruptcy that's a 3 to 5 year repayment plan, as opposed to a Chapter 7 debt liquidation bankruptcy that you're in and out so fast it doesn't tend to come up as often.
Well, in Chapter 7, you're in and out so fast, but you're still in and out for about 6 months. So are you telling me that none of our clients incur any debt during that 6 month period?
Well, I tend to plan and strategize with them so that we time it so that they don't tend to need to do that as much. So, for example, if someone has a car and, I'm about, want to file for bankruptcy, but the car is on its last legs, one of the things I'll tell them is, if you're going to get another car, get the car before you file for bankruptcy. Because, for example, in a Chapter 7 bankruptcy, as soon as you file the bankruptcy, car creditors tend not to work with you until you get your discharge. And that discharge is going to happen about 3 months after the filing of the case. So before you're in bankruptcy, they tend to work with you. After you get your discharge, they tend to work with you. But you get that sort of that 3 month donut hole, as it were, where you don't want to be in a situation where, hey, I don't have a car, and how am I going to get a car? So that's one example of many examples of how I try to time this with people to understand that you may have to tighten your belt a bit just for a few months until you get to the point where you get your discharge.
So part of what we advise people is you're going to file for bankruptcy, you're going to emerge all right and fresh. However, do know that there is this time period that you have to now prepare for, where we don't want you to incur any new debt. Don't put any more money on your on any credit card. Don't open credit cards. You will not be able to, during that 6-month period where you are in and out of Chapter 7, that's not the time you can go to a car dealership and get a car. And so forth, correct?
That's correct.
So practically speaking, somebody files for Chapter 7 and we're in that 6-month period waiting to get discharged. You don't want them to use credit cards, correct?
That's correct. And the funny thing is, sometimes people will tell me, well, how am I supposed to live and how am I supposed to pay food? And the funny thing is, oftentimes, what people get trapped in sort of what you'd call like a hamster wheel effect, because what happens is they aren't ready to file for bankruptcy yet, or they feel they're not ready to file for bankruptcy, even if the numbers would suggest to do so. But what they're doing is they're shoveling every available cent into the credit card furnace to keep their credit score good. Why do they keep the credit score good? So that they can borrow more money. Why do they need to borrow more money? Because they need to pay for things. Why can't they pay for things? Because they're shoveling every available cent into the credit card furnace. And then how do you ever break out of that circle? But what I tell people is, if you know you're going to file for bankruptcy, what you would do is you would stop paying on those credit cards. You would stop paying on those personal loans and the payday loans and everything else.
So we're talking about a month or two before you file for bankruptcy.
That's right. And if you're certain that you're going to file for bankruptcy, you stop paying on those things. And then you tend to, because you're not shoveling every cent that you have into the credit card furnace or personal
because
loans.
At that point,
you
that
can't
would
afford
be
to
paying
live.
good money after bad.
Exactly.
Save that $100 or $500 you were going to pay on the credit card. Don't add more debt because you're going to file for bankruptcy.
Yeah, it's just trying to get people off of the credit card steroids and try to get back into more of a cash system a little bit.
So, you advise people to be prepared for the 6 months ahead once they file for bankruptcy. That is paying the house or the rent. That is gas, food, paying car insurance, health insurance, credit cards, and so forth. Practically speaking, what do you tell people? Talk to your brother, talk to your sister, borrow some money, have somebody help you during that time so that you can make it through, because we don't want you to incur any new debt.
Oh, yes, I've absolutely, in appropriate cases, advised people that if you receive contributions from family members, again, not necessarily to pay off old debt, but we're talking about gasoline in the tank of your car, food in your stomach, washing the clothes, keeping the lights on, paying the car payment, paying the mortgage payment. People absolutely, in appropriate circumstances, do have assistance from family members. And that's okay so long as it's declared.
Okay, and will the check, let's say that a brother is helping his sister until she emerges from bankruptcy, pay her car note. Is it okay that the check comes out of the brother directly to the car company, or can the check come out of the sister who is in bankruptcy, where there is a stay?
I've seen it both ways. I've seen where a family member is paying on the car note. I've seen where a family member, yes, and I've also seen where a family member gives the person in bankruptcy money and then
deposited into the debtor's bank account.
That's correct. I've seen it both ways.
And there will be no questions from the bankruptcy trustee as to where did that money come from and what did you do with it? How did you come upon that money?
Well, there's different schedules and statements that have to be filed with the court. Two of those statements is a statement of regular monthly income and regular monthly expenses. So, and that should match reality. So if you have $300 a month that your brother is contributing to you to help you pay the car note, that's perfectly fine so long as it's accurately disclosed on the income schedule. But in that discussion that we had last week about Well, aren't there payments to insiders? Is that a problem? It's not what you have borrowed, it's what you've paid back. So you wouldn't want to pay back your brother or your cousin necessarily, while you're in bankruptcy. But it's perfectly fine if it's a gift, but so long as you're not paying them money, so long as you're not taking assets and moving it away from yourself, so long as you're not preferring one creditor over another, so long as you're not making payments to cousin Sam while you're in bankruptcy.
But if you're channeling money for a minute to pay ordinary expenses that are owed, that is okay.
That's okay so long as it's accurately disclosed on your income and expense schedule.
But when do you disclose? How often do you disclose? Do you disclose monthly?
No, even though it's called your monthly income schedule and your monthly expense schedule, you tend to file that one time in the case, unless there's some change in your circumstances while you're in the bankruptcy.
Okay.
Sometimes a person has a change of job halfway through the bankruptcy, and that's perfectly fine, but you want to amend the income schedule to disclose the new job and then, provide updated pay stubs to the trustee.
Okay. And I would like to remind the listeners that we are for the full hour talking about bankruptcy. So far, we've discussed surviving bankruptcy, secured credit cards, debit to credit ratio. We just talked about incurring new debt during bankruptcy, and we said that's a big no-no. And we've also talked about how to survive while you are in the middle of bankruptcy. In Chapter 7, it's easier because it's faster, because the whole thing may take up to 6 months. However, in Chapter 13, it's anywhere from 2 to 3 years?
3 to 5 years. By law, it can be no shorter than 3 years and can be no greater than a 5-year repayment.
So understandably, a lot of people would want to file Chapter 7.
That's correct.
And because Chapter 13 is a debt repayment, meaning that some things are wiped out and some things are your obligation. Chapter 7, everything is wiped out as long as it's not one of those non-discharged debts that you can never discharge.
Or also, too, you wouldn't be able to, discharge a mortgage but keep the house. You wouldn't be able to discharge a car note but keep the car. So that's a little bit of a difference between what they call secured debts versus your credit cards, medical bills, things like that. Of course, if somebody doesn't want to keep the house for whatever reason, they're 5 months behind and they know they can't save it, they have the option of surrendering the house back to the bank and not having to pay it anymore. Likewise with a car if they're behind. But you wouldn't be able to dump the debt and keep the item.
So if someone by mistake incurs new debt during the bankruptcy stay, you said it's a big no-no. What can happen then? What's the worst that can happen?
So, for example, if somebody gets a new car, and this is an example of, this wouldn't really happen in a Chapter 7 bankruptcy because, as we were saying earlier, the car creditors don't tend to work with you until you get your discharge when you're in a Chapter 7. But, for example, in a Chapter 13, it's a 3 to 5 year repayment plan. If you just go out and try to get a car, now as a practical matter, the car company, they're going to pull your credit report. They're going to see that you're in an active bankruptcy. And most reputable car companies, car financing companies, are going to want an order from the court saying that it's okay for you to actually do the deal. But every now and again, someone will push the deal through without getting the court's permission. It could jeopardize your discharge on the back end. Because it's definitely a breach of the bankruptcy rules. Sometimes you can fix that. You can file what's known as a motion nunc pro tunc, which is basically getting permission after the fact. But it can sometimes be fatal to your discharge, and that's the part that wipes out the debt when you get to the end.
We're talking a little bit about how there is some planning that goes into preparing for filing for bankruptcy, some financial planning, and your advice to clients about that. Are you saying that for those who don't have a car, go get a car before you file bankruptcy, Chapter 7 bankruptcy? Because while you're in bankruptcy, a lot of car creditors are not going to want to talk to you whatsoever.
That's correct. If someone can afford it. Now, one of the rules in Chapter 7 bankruptcies is that if making the payment on that vehicle would put your monthly disposable income into the negative, that gives rise to what's known as a presumption of undue hardship. Then you may have an additional hearing where you'd have to go in front of the judge and explain to the judge how you're able to make the payments on that vehicle.
On that Lexus.
Yeah, so a Lexus may not be the best thing right out of the starting gate. There's other more reasonably priced vehicles. You know, I was just saying to someone earlier today, you know, if your car payment's $300, $350, maybe it's $400, you're kind of pushing it when you get into the 500s. But, you know, if you have a $650 or a $700 car payment, you know, I think that trustee is likely to say, you know what, you know, I think you shouldn't be at Chapter 7.
In other words, they scrutinize what you call your expenses.
Yes, they have to be what's called reasonable and necessary. Now, there's no place on the Federal Register where you have a list of exactly what it is.
Or what undue hardship means.
Right, but you know, debtor attorneys do this thousands of times. Creditor attorneys are doing this thousands of times. The trustee and the court's doing this thousands of times. We all have kind of a more or less of a sense of what's reasonable and necessary for your household size. So even something like food, for example, the average adult, you're thinking about $200 to $250 worth of food, maybe $300 if you're including like household supplies and things like that you get at a grocery store. But if a household size of one comes in and they're saying it's $600, you may very well spend $600 on food for a household size of one, but they're not going to give you, so...
they're going to call it 300.
You know, exactly. So
they're going to assign a different number to it.
The imported lamb from the Salvaggios of the world may have to wait 6 months until you're not in bankruptcy anymore.
Correct.
Yeah, it has to be reasonable and necessary.
And we see that in looking at student debts, you've always said, because most people think that student debt cannot be discharged. Yes, generally not, but you've always said sometimes. It depends on sometimes. And in the analysis that we are about to engage in regarding student debts, they look at that factor a lot. Undue hardship, which is nowhere defined in the bankruptcy code. And they look at what you call expenses. You can't, you know, have an expensive expensive taste and have live in a 4-bedroom apartment when you can live in a single-bedroom apartment and give to charity and pay for a timeshare and call these expenses. So we'll talk about that in a minute. Since we're talking about cars, surviving bankruptcy and recovering from bankruptcy. So we said that credit cards are more readily available to you than you think. You may not like the interest rate, but you'll be able to open a credit card. The getting a car. So let's say you could not afford to get a car and you filed for bankruptcy and now you're discharged from bankruptcy and you want to get a car. How soon, generally speaking, after you emerge from bankruptcy, will a car creditor talk to you and give you a car?
Immediately upon receipt of the discharge. It may not be the best interest rate right out of the starting gate, but
much like with credit cards.
Yeah, well, once you've received your discharge, if you have some revenue source and a pulse in America, you can get a vehicle.
All right. So in recovering from bankruptcy is a two-part factor. There is your ability to access things and how expensive it is, and your credit score, and they're related. So it takes time to build the credit score, but you're building it slowly but surely. The most important, impactful time is the first year and a half after bankruptcy, and as long as now you are paying your bills on time and you're not late and you're not incurring a lot of debt, not more than 40 to 50% of what you can put on your credit cards, then your credit score slowly but surely is starting to go up, and within a year and a half you will start being pleased with the credit score. 1, 2, right from the get-go, if you need a credit card to live, if you need a car to drive to your job or from point A to point B, You will be able to have a car, you will be able to open a credit card, but you may not like the interest rate you're being charged. Correct?
That's correct. And even if the interest rate isn't the greatest, simply getting something you can afford, it may not be, again, it may not be a Lexus right off the bat, but you make those payments over time, the credit score improves, and then the cost of borrowing money for you will go down over time, so long as you're making all those payments on time.
By the way, once you emerge from bankruptcy, once you're discharged, nobody cares about your expenses anymore, right?
That's right.
You don't owe the court or the trustee an explanation for why you decided to go get a Lexus, not a Honda.
Yeah, I mean, the day after you're no longer under the jurisdiction of the bankruptcy court, if you want to go sign up for a Lexus, you can do that. Although, again, proceed with caution because you can only file a Chapter 7 bankruptcy once every 8 years.
Okay. Student debts. We said that there are a number of debts that you cannot discharge even if you file bankruptcy. And again, when we say discharging a debt, meaning wiping it, forgiving it, meaning you don't owe that creditor money anymore. That's why people file for bankruptcy, because they want to get rid of all this debt and start again. And generally speaking, yes, you can. There are certain debts. We've talked about that more than once. It bears repeating. Even if you file for bankruptcy, you cannot wipe out. One of which is student loans. Again, like every general rule, there are exceptions. I did extensive research on student debts and why is it that you cannot, generally discharge them. And those who succeeded, because let's tell the listeners that some people have succeeded in filing for bankruptcy and convincing the court that their student loans can be and should be forgiven. It is a very difficult test. However, we will talk about it. I want to tell you that the studies I looked at state that last year, in 2018, American student loan debt totaled almost $2 trillion. So there is $2 trillion in outstanding student loans out there. And so that is why, given this number, almost $2 trillion, that is why everyone who runs for president talks about it. I remember President Obama. I heard him talk at the University of Michigan stadium. And he said, Michelle and I have student loans. And he was talking about the power of education. He talked about student loans. And everyone who runs for U.S. president, that's part of their talking points. And I can assure you, it will become a talking point again. What about some of the people who are currently running in the primary? Attorney Michael Bankstein talked about it, like
Elizabeth Warren has talked on that issue many times. Bernie Sanders. There's a number of people that are all staking out a position. Again, I'd point out to people that whoever winds up becoming president still has to deal with Congress, and they have their own views on this as well.
Correct. And also it's talked about. There is another place it's talked about a lot. I'm talking about student loans, not only among presidential candidates trying to win the votes of people who are still paying student loans, but it's also increasingly talked about in bankruptcy court proceedings, correct?
Oh, absolutely. Courts are really grappling with these issues around the country.
And I was surprised from my research to discover that if you show the right factors, and there are primarily 3 factors, difficult to show. But if you show, you may be able to get off your outrageous student loans, correct?
That's correct.
Okay. And there is a case, the Brunner case?
That's correct.
That every federal court, bankruptcy court is applying, that is really saying that if you can show to us 3 things, that means that your student loan is an undue hardship on you. It is such a hardship that we are going to forgive you that loan. And the first part of the loan is you have to show today, so you've been a student, you incurred $175,000 in student loans, forward to today. Today you're working or you're not working. Today you've already accumulated your student loans. Today you have to show an inability to maintain. You have to show that your actual monthly income minus your reasonable monthly expenses will put you in the negative. Correct?
That's correct. Yeah, the actual monthly income minus reasonable monthly expenses would have to result
in a negative.
In a negative. The smaller than the current monthly payment on the student loan debt.
So in other words, if my payment is $2,000 on my student loan every month, but I make $2,000 and I spent $1,600 in reasonable expenses, that only leaves me with $400. I cannot pay the $2,000 student loan.
That's correct.
The key here is the expenses. You can't spend whatever you want and buy the expensive pork chop from Nino Salvaggio, imported from which country in the world? Let's say Brazil. They have good pork chops, and call that a reasonable expense. Your monthly expenses are going to be scrutinized.
And not just the expenses either, the income as well. They'll look at this on the income side. So when a younger debtor is underemployed, the court's going to look very carefully at whether the debtor's intentionally not pursuing job prospects that would increase the income.
Sure. And for example, expenses of what they call reasonable or not reasonable. Are you paying for somebody else's, payments? That's not reasonable. So here I am not wanting to pay my student loan, but I'm paying for my brother. Or do I pay a car lease and I have another car? Or, do I pay for a 2-bedroom apartment $1,200 when a single bedroom apartment costs $900 and is available? Do I give to charity? That's not a reasonable expense. In this context, you're trying to get out of paying your student loan, but you want to give to charity. Or you want to get out of your student loan, but you're telling the court that, you have a timeshare and you want to pay for a timeshare. So, maybe small items like a $50 monthly gym membership may be okay. But the big ones, unless they're really reasonable and needed, they're not considered to be reasonable expenses. Correct?
That's correct.
Okay. The second part for proving that maybe your student loans should be forgiven is a situation for tomorrow. And that's not today, that's tomorrow. Is your situation likely to continue in the future? The situation that's making you today say that my income and my expenses put me in the negative if I pay my student loan.
And that's right. And the court looks at a number of factors. They look at the debtor's job skills, your age, your health, the number of working years remaining, and whether or not the debtor's maximized some other income potential.
Right.
So very fact specific.
Yeah. For example, there was a 44-year-old substitute. So I apologize. There was a person who was not even trying, an unemployed 60-year-old woman who is still required to pay her student loans. She's 60 years old. She's unemployed. She's living on food stamps. But all she does is do volunteer work, and she never tried to pursue a job, a paying job. The court said, you're not helping yourself because you did not try to pursue a paying job. So you are kind of sabotaging yourself, but you want to take advantage and not pay your student loans. So they look at like a totality of circumstances. I'll give some examples of cases where the court said, looks like your situation is not going to change, so we will consider forgiving your student loans. For example, a 43-year-old social worker who can only work 32 hours a week, and if you take her income and her expenses, she could not pay her student loans. Or a 44-year-old substitute teacher who had a lot of chronic and progressive medical issues.
I also like that example that they gave in the case of some of the cases of a 56-year-old woman working as a social worker with a long history of making a modest salary.
Right, and she could not prove that she can do better. Or the 56-year-old man with a law degree who tried and tried and tried but failed to make a career as a lawyer. That person was forgiven his student loans. On the other hand, there was an unemployed 62-year-old man who had large student loans, whose law license was suspended, but who had 20 years experience as an accountant. They said, no, your income is good and your situation is good into the future, and we're not going to forgive you your student loan.
Right, and there was a 51-year-old employed in marketing with some risk of losing a current job, but who sent out only 10 resumes recently, and whose financial problems arose from poor decisions.
Okay, so it's almost self-sabotage or career sabotage. So when people are sabotaging themselves or not helping themselves, those factors are not helping them plead their case in front of a bankruptcy court as far as forgiving their student loans. How about we talked about that. How about the unemployed 60-year-old woman who is living on food stamps, who is doing volunteer work for 10 years, but never tried to pursue a paying job? She does not want to get a job. The court said, you're sabotaging yourself. You are not helping yourself. What about the 68-year-old retired government employee who is still facing student loans at age 68, who showed no medical evidence that, he cannot get a better paying job than the job that he is getting? So there seems to be a lot of, how shall I say, the courts are requiring that you show that the income you make now and the reasonable expenses that you are spending now, put you in the negative after income and reasonable expenses. And reasonable is key to expenses here. And that in the future, there is no likelihood that your situation is going to improve.
That's right, and they're not looking out just a few years. They're looking to see a different timeline. More, does it look like you're going to have these problems for decades?
Correct. Or whether those problems, may decrease over time, or whether you're going to face them for decades. And they say that this part of the test is the hardest part to prove to a court, that your situation is likely to stay just as bad.
It is. That's why I think when a lot of bankruptcy attorneys say that student loans are generally not dischargeable, it's kind of shorthand for it's really hard to have the appropriate set of facts for you to meet this second prong of the test.
But from doing this research on student loans, I became more and more convinced that yes, in the right case, some people can get their student loans waived, and you've always said that. We never talked about it in great detail, and I know I do believe you, and I know you know your stuff, but by reading about all this, really what was impressed upon my mind is that in the right case, under the right circumstances, the courts will forgive somebody their student loan.
Oh, absolutely, given the right set of facts.
You're right. And there is a third part to that test. And the third part to that test, you talked about it before in another context when you talked about good faith effort. In what context did we talk in a previous show about good faith effort? I know it came out, I don't know if you do remember, but it came out in one way or another. At any rate, you're looking like you don't remember, so...
Well, it's variations on a theme. I definitely recall, having discussed that many times. So good faith effort could be in the context of a Chapter 13, having to pay what you're able to pay. So not expanding your expenses on your expense schedule to, in effect, subsidize at the expense of your creditors, expenses that aren't really reasonable and necessary for your household size. Or good faith could even be, incurring debt in the 90 days before the case is filed. So good faith can take a lot of different elements here.
And in this particular case, good faith meaning, have you done your best to repay your student loan? Have you made any payments? Those who have not made any payments will not be looked on favorably at all.
I found it particularly interesting when they were discussing the income-based repayment programs, is that even though it's not an automatically that you can't get your student loans discharged if you never pursued an income-based repayment plan, but it did seem to help some debtors that had at least, prior to the bankruptcy, pursued income-based repayment programs and tried to make some payments, for some time. Particularly debtors who never made a payment on their student loans. But that was a pretty tough row to hoe, trying to say that they're not going to be able to that the court's going to try and discharge that debt if there's never been an effort to try and repay it.
Right. I think that we have given enough examples to our listeners about cases where the court said, yes, under those circumstances, your student loan will be forgiven, and no, under those circumstances, your student loans will not be forgiven. I think that we've driven the point across that the student loans are generally difficult to forgive, but not all the time. That sometimes bankruptcy courts do forgive under the Brunner, Brunner case, do forgive student loans. There is even talk about, you want to say something? Go ahead.
I'd love to just throw two more examples in to really kind of give it a good bookend, particularly when you're talking about this third prong, that you're not the one who's tried to, create the problem, that you're trying to solve the problem. Here's an example of a good faith standard that was met. You had a debtor who had 33 payments, and even though they were kind of small,
33 payments,
nominal payment, made 33 payments, and had 12 years of loan payments and extensively networked to look for a better job. And that was a case in which it was found that they were trying in good faith to resolve the matter. The bookend example is there was a debtor who made no payments, sought deferment, filed for bankruptcy within days of the first payment coming due, and inquired about an income-based repayment program only after filing for bankruptcy and then rejecting it. So that's a really good example.
And of course the court frowned upon that and said, we are not forgiving you your loans.
Right. I mean, you know it when you see it. I think that if someone's making an effort to repay the debt versus never having made an attempt to do so.
In fact, we were talking a few days ago with attorney Katie Plague about people who fall behind on their child support payments. And although technically under the law here in Michigan, it is a crime, it is a felony punishable by 4 years of prison, she did state that sometimes there are reasons for why people cannot make their payments in full, Michael. But she said that any payment, and she talked about good faith there too, she said any payment is better than no payment. So you may not be able to pay your $1,000 child support for this month, but if you pay $200, it may go a very long way in the court, looking upon you more favorably than if you did not pay at all. And that seems to be the same. And she did use the term good faith. So maybe I seem to remember that not from a discussion with you earlier, but a discussion with Katie Plague within the context of making any payment when you owe child support, even if you cannot afford to pay the whole payment.
Well, that's definitely a thread that's woven, throughout the law in various areas, that you have to act in good faith.
Right. So again, all of the debtors are going to have a sympathetic story to tell, but it's going to boil down to these three factors. What's your income to your reasonable expenses today? Is your situation that's putting you in debt situation today likely to continue, or is it of your own making? Are you doing anything to help yourself? And have you acted in good faith to pay what you can? And to summarize, because bankruptcy courts are here and there forgiving student loans, I think that you, attorneys, bankruptcy lawyers, can sometimes, and by the way, some decisions have allowed the discharge of the debt in part. It doesn't have to be all of it. So sometimes the court will say, okay, we will wipe out a portion of your $175,000, but not all of it. So
I've even occasionally seen private student loan providers charge off the debt as a result of the filing of the bankruptcy. I don't want to oversell that, but I've seen that as well.
And you've stated that these decisions in court, where we now know that under the Brunner case, under the right circumstances, some federal judges are forgiving loans in whole or in part, you're using this as a leverage in negotiating with creditors, correct? What
That's
you
correct.
start talking about the Brunner three-factor test, and you start, telling the creditor and the bankruptcy trustee, listen, my client, the debtor, if need be, will pass the Brunner test if we go to court, and if we go to trial, we'll be able to show the first part, the second part, the third part. And I think that may allow some creditors to calculate the risk they have under those discussions, and they may even consider negotiating with a lawyer who's representing a debtor. Am I correct?
That's absolutely correct.
Okay. And do you have anything else to add as far as student loans? I love this. I love that now I am convinced, not that I've ever doubted you, but now I understand why. How about that? I understand when you say it depends, and sometimes you can and sometimes you can't, when you've always stated that student loans may or may not be dischargeable in bankruptcy. So again, if you demonstrate these three parts to the Brunner test, in other words, if you can demonstrate that paying the student loans that you have will cause you an undue hardship, then you may be able to have that student loan in part or in whole discharge. And by the way, you said that in the beginning, that the bankruptcy code nowhere does define what undue hardship means.
That's correct.
So,
that's one of those gaps that the courts have had to figure out on their own.
right. So that's why the bankruptcy courts are figuring that out one case at a time. What does it mean, undue hardship? What does that mean?
Undue hardship means basically that you don't have any ability to make those payments
today,
Yeah.
not likely to make them in the future,
Right.
and have not, and in good faith have tried to do everything you
Right.
can.
The court recognizes that you don't have to be, eating soup and crackers for the next 20 years. If you just can't do it under the appropriate circumstances, you absolutely can seek to have the court discharge that student loan debt. And in appropriate cases, they'll do so.
I want to remind the listeners that anyone who wants to listen to this discussion again, it will be available in a few days on our website at yourrights.radio, and at the YouTube channel. You can thank you. Go ahead, Michael.
I was going to say, we also are on the YouTube channel.
Correct. And we've been doing a fabulous job downloading the information almost simultaneously, quite often on the same day, correct?
That's correct.
And if you subscribe to the YouTube channel, which is the Joumana Kayrouz YouTube channel, then you will get a notification every time we download a program. And not only does every day offer a new program, Monday immigration, Tuesday bankruptcy, Wednesday personal injury, Thursday social security and workman's compensation, and Friday criminal and family law, but you can click on the show It will say what it is just from looking at the image. And if you want to know what is it that was discussed, you will click on the show, you will click on the drop down, and there will be a bullet point of the major points discussed. For example, like today, if I were to summarize it, I would say surviving bankruptcy and emerging from bankruptcy, incurring new debt during bankruptcy, and student loans. So this way, those who are interested in student loans can click on today's show and will listen to it. And if the bullet points are about subjects that are of no interest to them, then they don't have to listen to it. Thank you very much, Attorney Michael Bankstein.
Thank you so much, Joumana.
We very much appreciate your knowledge and your expertise.
Thank you. I appreciate you. And thank you, Rami.
And Rami, we thank you very much. We thank the listeners. And until tomorrow, God willing.
إن شاء الله. تحياتنا لك جوانا ونشكر لكل مستمعينا حسن المتابعة. إلى اللقاء.